Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I think this is live stream number 3 today, possibly 4. I know we did a members only stream early this morning, and then I did so much stuff after that that I forgot. So I just want to start out by saying the rumors are true. I do have a pimple, as you can see. All right. So somebody says, I see a lot of activity on Court Listener. Yes. So I've had most of that. This just came out. So earlier I did that stream, that really short stream, talking about how they had filed a Jed Wallace and Street Relations, the crisis PR firm that allegedly helped this weird plot to take Blake Lively down. Okay, so they filed a notice of motion to dismiss, but they had not yet posted this memorandum, which gives, a lot of the detail as to why they want it dismissed, because they wanted to redact one small paragraph which talks about Jed Wallace's health conditions, and that makes sense. And you'll see the redacted part here. So we'll get into that. Some of the really interesting stuff is in the declaration, which is going to be towards the end, but it's not a super long document. We will skim through some of the case law stuff as always, because I know the lawyers like Omar, the tilted lawyer, and the two lawyers, Ask Two Lawyers, they're going to go over that kind of stuff, I'm sure. So we'll just get through the narrative part of it, and the declaration is where the spicy stuff is. So you'll like that. All right. Sorry, I got to share my screen real quick. I had it and then I accidentally closed it. So that's pretty par for the course. Okay. So I know it says 260 something pages. It's not. So this first part that we're going to go over, it's like 30 pages or so. And then the declaration is really short. It's like 3 or 4 pages. And everything after that is actually just a copy of the CRD complaint, the precursor and all that. So I'll post this if anybody wants to go through all that, if you're dying to go through all that. But it's all stuff that I've read on this channel before. It's all stuff that most of you have seen by now before. So, we won't waste time going through all of that. We're just going to do the top part here, the memorandum in support of the motion to dismiss, and Jed Wallace's declaration, where he says, basically he says, I've never met Blake Lively, and I did not, do anything regarding her imagined desire to take her down or whatever, which is really actually pretty funny. So, all right. Let's do this. Jed Wallace and Street Relations, Inc. moved to dismiss the claims of Blake Lively brought against them for the first time in her amended complaint. For 1, lack of personal jurisdiction, 2, improper venue, and 3, failure to state a claim. In the alternative, defendants moved to sever the claims against them and to transfer venue to the United States District Court for the Western District of Texas, where a previously filed case involving the same parties and allegations is pending and where Lively's claims could have been brought. So remember that Jed Wallace did file a lawsuit against Blake Lively in Texas because he was not, and he was also not named in her original complaint. But when she did her first amended complaint after he had filed his lawsuit in Texas, then she named him as a defendant in this lawsuit. So just for some context. It's like background. The rules regarding motions to dismiss are familiar, and for failure to state a claim, the court is limited to reviewing and assuming to be true the well-pleaded allegations of the amended complaint, as supplemented by any documents incorporated by reference. For the personal jurisdiction and venue motions, the court is not so limited, but may also consider any affidavits, declarations, or exhibits submitted by the parties. Okay. And then they mentioned here in the footnote that neither Wallace nor Street Relations, Inc. Were sued in the original complaint. Okay. On footnote number 2, which they'll talk more about down here, it says Lively previously sued Wallace in Texas State Court within the Austin Division of the United States District Court for the Western District of Texas, making virtually identical allegations to those she asserts here. Lively non-suited that case without prejudice on February 4th, 2025. Okay. So that was where she had tried to depose him in Texas. Okay. We know the parties already, so I'm not going to go through that. Alleged jurisdictional facts. Lively alleges on information and belief that Wallace was hired in early August 2024 to design and implement the other defendants' social combat plan, and he specializes in executing confidential and untraceable campaigns across various social media platforms, including TikTok, Instagram, Reddit, and X, to shape public perception of his clients and their adversaries and to perpetuate those perceptions. There is no allegation that any of this activity took place in or was directed at New York, and Lively has judicially admitted that Wallace worked remotely from home in Texas. See Exhibit 1 to the Wallace Declaration, which is what I said has a lot of that kind of interesting stuff in it. Indeed, Wallace denies that he engaged in this conduct at all. Now, I just want to point out, I don't know much about Jed Wallace at all. I've had a couple people comment on my videos saying, hey, like, I don't think that necessarily, I don't believe what Blake is saying, but this guy's kind of a shady character. And I gotta say, I'm not gonna really comment on that at this time, just because I don't know anything about the guy. If I have a chance to look into it more, then I definitely will, kind of walk you guys through that. But that's just what I heard briefly. And I just want to say, like, I don't have enough information to really make that kind of sweeping declaration per se, All right. On information and belief, the AC alleges that Wallace and Street were to weaponize a digital army around the country, including New York and Los Angeles, to create, seed, manipulate, and advance disparaging content that appeared to be authentic on social media platforms and internet chat forums. Wallace is also said, on information and belief, to transact and solicit business within the state of New York. It is alleged that communications were had with at least one journalist at the New York Post and another at the New York Times. Well, pot made kettle, bro. Though the AC does not specifically claim that the communications were with Wallace. In any event, he denies communicating with the Post or the Times, that he transacts or solicits business in New York, or that he was asked to or did weaponize a digital army across the country and or targeted New York and Los Angeles. Okay. He never published, directly or indirectly, any information or content concerning plaintiff Blake Lively. And his assignment was to monitor and analyze the media climates regarding the film Lively and Baldoni, and his communications in that regard were with residents of California, not New York. Okay. And so in that declaration, it says see Wallace Declaration. We're going to see like why he made some of the comments and stuff like that Blake Lively had included in her complaint to provide some more, context and all that. So, yeah. Okay. Other evidence related to personal jurisdiction. So we won't go through like all the case law stuff related to this, like I said, because this is not super, pertinent to the narrative. Okay. On January 21st, Lively sued Wallace in Texas, but ultimately non-suited the case on February 4th, claiming that the day before, at a pretrial conference in this case, counsel for Wayfarer, who is also counsel for Mr. Wallace, took the position that the underlying disputed issue in the Texas case being raised and litigated in SDNY. True and correct copies of this petition and the motion to non-suit are attached to the Wallace Declaration as Exhibits 1 and 2. The statement to the Texas court is false. First, the undersigned was and is Wallace's counsel in this case and the Texas case, a fact that was known to Lively's Texas counsel on the day she made the above representation to the Texas judge. Whoops. Second, the undersigned did not appear at the February 3rd hearing for the simple reason that Wallace had not yet been sued in this case and therefore could not have made and did not make the representation attributed to him by Lively's Texas counsel. Third, Wallace was not mentioned at the February 3rd hearing, and there was no representation by Wayfarer's counsel or anyone else that claims against him could or should be litigated in SDNY, the Southern District of New York. We asked the court to take judicial notice of the transcript on the February 3rd, 2025 hearing, which I've published on my page, guys, if you still haven't seen that. Okay. The Texas case petition alleges, just as she does in this case, that Lively and others on the set of the film were subject to a pattern of unprofessional and sexually harassing behavior. And thereafter, she was subjected to a retaliation plan. The allegations in the Texas case regarding Wallace are repeated almost word for word in this case. Okay. The Texas case also contains Lively's sworn judicial admissions that 1. Wallace worked remotely from Dripping Springs, Texas. 2. A substantial part of the events giving rise to the claims that she seeks to investigate, specifically Mr. Wallace's work on the social manipulation campaign, occurred in Hays County, Texas. And 3. A substantial part of the underlying events that would give rise to the claims against Wallace being investigated occurred in Hays County, and Mr. Wallace resides in Hays County. Okay. The first filed case was commenced in Austin Federal Court on February 4th. Shortly after the Texas case was non-suited. A true and correct copy of that pleading is attached to the Wallace Declaration as Exhibit 3. And if you guys still haven't seen that, you can go see it in my live streams on YouTube. You'll see when it says Lively being sued for, I think it was no less than $6 million or something. I can't remember exactly what it was, but you'll be able to find it there. Okay. The first filed case asserted claims for declaratory judgment and defamation. The latter occasioned in part by Lively's publication of allegations that Wallace and Street had sexually harassed her on the film set, naming them as respondents in a complaint of employment discrimination filed with the CCRD and leaked to the press, as plaintiff admits. The CRD complaint is attached to the Wallace Declaration as Exhibit 5, and the pleading attached to the CRD complaint and made part of it is attached at Exhibit 6. These allegations are demonstrably false, as neither Wallace nor Street had anything to do with the movie's production, and were certainly not on the film's set. This is actually really funny. Hey, Crow, what's up? Yes, thank you, mods, and yes, please hit the like button for me if you can. If you can't, then why not? Okay. Wallace attended college at Fordham and moved back home to Pennsylvania. Okay. Since then, Wallace can only recall having visited the state of New York on 4 occasions, 2007, 2008, 2009, and 2024. Wallace conducted no business on any of those 4 trips. Wallace does not own, use, or possess any real property situated within New York. Wallace has been the sole owner and president of Street Relations since its formation. Okay. Procedural history. Plaintiff initiated this action by complaint filed on December 31st. Okay. She filed her amended complaint on February 18th, adding Wallace and Street as defendants. Summons was issued to Wallace and Street on February 24th and was served on February 26th. Okay. Legal standard. On a Rule 12b2 motion to dismiss for lack of personal jurisdiction, the plaintiff bears the burden of establishing that the court has jurisdiction over the defendant. We won't go through that too much, guys. Discussion. Defendant should be dismissed because plaintiff has failed to establish that the court may exercise personal jurisdiction over them. In cases like this one, federal courts are to apply the personal jurisdiction rules of the forum state, provided those rules are consistent with the requirements of due process. In New York, there are 2 ways to exercise jurisdiction over a non-resident. General jurisdiction pursuant to New York CPLR, Section 301, and specific jurisdiction pursuant to New York CPLR, Section 302. In this case, the plaintiff, Blake Lively, relies on both. And it says, see amended complaint. So those are the citations in there. All right. Specific jurisdiction. Like I said, guys, we're not going to go through too much of this part. The New York long-arm statute does not extend in all respects to the constitutional limits established by International Shoe Company versus Washington and its progeny. Okay. So in determining specific personal jurisdiction over a non-domiciliary, New York courts engage in a 2-step analysis. The first step is the application of New York's long-arm statute. If the exercise of personal jurisdiction is deemed appropriate, the second step is to determine whether to determine whether personal jurisdiction comports with the Due Process Clause of the United States Constitution. Plaintiff satisfies neither step in this case. Okay. So we're going to skim through the rest of this jurisdiction type stuff because, like I said, the lawyers are going to go over this part. If I see anything that sticks out here, I'll stop. And like I said, I'm going to post this document right after this stream, so you can always read through the whole thing yourself if you don't want to wait for the lawyers to go over it. All right. The only concrete allegation connecting Wallace and Street with New York is a group allegation with other defendants that Ms. Nathan, Mr. Abel, do you mean Miss Abel? Ms. Nathan, Ms. Abel, Mr. Wallace and Street targeted New York by, among other things, communicating with or causing content to be provided to journalists, content creators, and media entities based in New York, including at least one journalist at the New York Post and another at the Times. Okay. That allegation is unequivocally controverted by Wallace and Street because neither Wallace nor Street communicated or caused content to be provided to journalists, content creators, or media entities in New York. In fact, Wallace's role was not to post anything on the internet, and he even advised the Wayfarer team that there was nothing for them to do. Wallace did not speak to a journalist at the New York Post or at the New York Times. A lot, right? Then. All right. Lively's allegations are nothing more than conclusory allegations based on information and belief regarding Wallace and Street. And then we're talking about general jurisdiction. It says there's no general jurisdiction over Wallace or Street. Plaintiff's sole allegation regarding general jurisdiction references Section 301 and concludes all defendants systematically and continuously conduct and solicit business within New York and have availed themselves of the privileges of conducting business in the state of New York. Which is not true, I guess. So, Wallace is domiciled in Texas. There is no general personal jurisdiction over Wallace. Street is incorporated in Texas, and its principal place of business is Texas. Okay. Lively does not allege any facts making this an exceptional case, excusing her from the at-home rule that a corporation's general jurisdiction is limited to its place of incorporation or principal place of business. Conspiracy jurisdiction. Okay. In a single paragraph, plaintiff alleges without specifically mentioning Wallace or Street that this court may exercise personal jurisdiction over defendants because, as further alleged herein, defendants each participated in a civil conspiracy and, on numerous occasions, individual co-conspirators engaged in overt acts in furtherance of that conspiracy that had sufficient contacts with New York to subject that co-conspirator to jurisdiction in New York. Plaintiff then provides just a few examples, which list New York activities such as January 4th meeting, which, if it occurred, is months prior to when plaintiff says Wallace and Street were first involved in this matter. All of the other examples relate to other defendants, with the exception of the group allegation, which Wallace and Street have denied. Okay. Plaintiff's 15th cause of action, conspiracy, consists of 4 one-sentence paragraphs which make no additional factual assertion. Although conspiracy jurisdiction exists, federal courts have been increasingly reluctant to extend this theory of jurisdiction beyond the context of New York's long-arm statute. Sure. Hold on. Guys, who is Chad? Chad is suing her back. Are we talking about Jed? Or is there a Chad? I don't know who Chad is. Anyways, moving on. Okay. To allege a conspiracy theory of jurisdiction, the plaintiff must allege that 1, a conspiracy existed, 2, the defendant participated, 3, a co-conspirator's overt acts in furtherance of the conspiracy had sufficient contacts with the state to subject that co-conspirator to jurisdiction in that state. Because Wallace did not participate in this conspiracy to commit tortious conduct or unlawful acts against Lively, negating element 2, there is no personal jurisdiction. Lively never connects the dots in her conspiracy allegations to her factual allegations, but Lively alleges a retaliatory scheme to silence her and others from speaking out about the hostile environment, and that Wallace and Street engaged in a retaliation scheme against Miss Lively relying on direct and constant media engagement, the seeding of content on traditional and social media platforms, the boosting of content, sometimes the very content that Tag and its affiliates had seeded, the suppressing of negative content about Mr. Baldoni, and the amplifying of negative content about Miss Lively, including through engagement via comments on social media. No, dude, no. Those are just people who don't like you. They're not, it wasn't a conspiracy. All right. But Ryan is indeed Chad. Okay, Chad. Got it. Okay. If that conspiracy exists, which Wallace doubts, he has no knowledge of it because he was not involved. Okay. One sec. Again, Wallace's involvement was to mere passive observation and analysis of the media environment. After that observation period, Wallace's recommendation was that there was no public relations damage control to do. Wallace's assessment instead was that people organically supported Baldoni and disliked Lively for her tone-deaf promotion of the film. Wallace had no desire to, nor did he damage Lively or her reputation, nor did he act on the imagined desire with anyone. There it is, the imagined desire. But we'll hear more about the imagined desire in the declaration. Further, a civil conspiracy requires an underlying tortious act. For the reasons below, Lively fails to state a claim that Wallace or Street relations, not retaliation, oh god, engaged in any tort. All right. Due process. Even if defendants' activities subject them to jurisdiction, the court must still determine whether the exercise of jurisdiction would comport with a due process clause. This analysis proceeds in two steps. First, whether given the totality of the circumstances, that is, the quality and quantity of the defendant's contacts, due process is satisfied. And second, whether the assertion of jurisdiction would satisfy fair play and substantial justice. There is literally nothing in the amended complaint that supports the notion, fundamental to due process, that defendants availed themselves of the privilege of doing business in New York. And when considering fairness and substantial justice, the court should keep in mind that Lively sued Wallace first in Texas. She claims in this case that he violated California law, and if California law applies, it is not New York that has the most significant relationship to Wallace's and Street's conduct. Furthermore, there is already a forum, Texas, previously invoked by Lively, which awaits her potential compulsory counterclaim. Okay. Venue. The court's analysis of the amended complaint is the same under the rule governing dismissal for improper venue as it was for personal jurisdiction. It requires a two-step process. First, they need to identify the nature of the claims and acts or omissions that plaintiff alleges gives rise to the claims. And second, they should determine whether a substantial part of those acts or omissions occurred in the district where the case was filed. Here, two of the three substantive claims are expressly based on California substantive law, and under the recognized choice of law analysis applicable to this case, for California law to apply, then a substantial amount of the events must have taken place there, not New York. In fact, as we have explained, all of the events regarding Wallace and Street occurred in Texas, as plaintiff has admitted. And of course, as we have pointed out before, and will again, neither New York nor Texas recognize one of plaintiff's claims, false light. We also note that plaintiff's reliance on Section 1391C for Wallace is misplaced. Plaintiff admits that Wallace, a natural person, is a resident of the judicial district in which he is domiciled, which is the Western District of Texas. Gosh, I can't talk today. Okay. So we're going to skim over some of this here because, again, it's kind of repetitive and it's stuff for the lawyers to really break down. Transfer venue. A district court may exercise its discretion to transfer venue for the convenience of parties and witnesses in the interest of justice, or simply in the interest of justice. Transfer the case to any district in which it could have been brought, without specific regard to convenience. Among the factors to be considered are the plaintiff's choice of forum, the convenience of witnesses, the location of relevant documents and relative ease of access to sources of proof, the convenience of parties, the locus of operative facts, the availability of process to compel the attendance of unwilling witnesses, and the relative means of the parties. Okay. The first filed rule puts a large thumb on the scale in favor of transfer. It states that in determining the proper venue where there are two competing lawsuits, the first suit should have priority. All right, then. Wallace filed his claims for defamation and declaratory judgment on February 4th. Lively did not add Wallace until 2 weeks later. Okay. And then when they talk about the convenience of parties, that's where the medical information is redacted. So this has something to do with his medical condition that he does not want the public to know about, which I think is, fair. So. And further, travel to and from New York would be hard financially on Wallace in two ways. Not only would consistent travel be a major expense, it would also disrupt his ability to make a living, as he does most of his work in Texas. Okay. In sum, the weight of these factors, and particularly the first filed rule, weighs in favor of transfer of Lively's claims against Wallace and Street to Texas. All right. Now we have failure to state a claim. To survive a Rule 12b-6 motion to dismiss for failure to state a claim, a complaint must include sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. A complaint must offer more than labels and conclusions, a formulaic recitation of the elements of a cause of action, or naked assertions devoid of further factual enhancement. The ultimate question is whether a claim has facial plausibility. The plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Determining whether a complaint states a plausible claim for relief will be a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. Put another way, yes please, the plausibility requirement calls for enough fact to raise a reasonable expectation that discovery will reveal evidence supporting the claim. Okay, thank you for clearing that up. All right. A, false light. Under New York choice of law principles, either New York or Texas law applies to Lively's false light claim. Under Lively's theory of venue and personal jurisdiction, New York is the epicenter of this case. If the court is reaching the merits, it is necessarily accepting plaintiff's theory that New York has the most significant relationship to the claims, and certainly to the exclusion of California, where no conduct is alleged to have taken place. New York applies the law of the state with the most significant interest in the litigation. If New York law applies, Lively's claim for false light must be dismissed because there is no tort of false light invasion of privacy under New York law. The result is the same under Texas law. As for B, intentional infliction of emotional distress, which is, kind of hilarious to bring that back up because, her husband's in his motion to dismiss against Baldoni complaining about hurt feelings and all that, but your wife is suing for intentional infliction of emotional distress. So at least be consistent. Okay. Lively concedes that she is a public figure. As such, she must satisfy the constitutionally required actual malice standard as an element of her claim. Actual malice means that a public figure may not recover for the tort of intentional infliction of emotional distress without showing in addition that the publication contains a false statement of fact, which is made with actual malice. For example, with knowledge that the statement was false, or that it was made with reckless disregard as to whether or not it was true. All right. There is no pleading that Wallace or Street made any particular false statement, but only that defendants, without distinguishing among them, publicly disclosed information or material regarding plaintiff's marketing decisions, moral character, private life, and family, which showed Miss Lively in a false light. As to actual malice, she pleads only that the undifferentiated defendants knew the public disclosures would create a false impression about Miss Lively or acted with reckless disregard for the truth. In addition to failing to plausibly allege actual malice, the conduct at issue, whatever it is, cannot possibly satisfy the outrageousness element. I kind of like that outrageousness element. That is, the conduct must be extreme, outrageous, and beyond the bounds of decency. and to be regarded as atrocious and utterly intolerable in a civilized society. As this court explained, intentional infliction of emotional distress, which they're calling IIED, is a highly disfavored tort under New York law. Even if plaintiff's allegations are plausible, and they are not, it is hard to imagine how a public relations point/counterpoint between two actors, 3 if you count plaintiff's husband, could rise to a cognizable IIED claim. This one does not, even giving plaintiff's deficient pleading all benefits of doubt. Aiding and abetting harassment and retaliation under California law. The final claim against Wallace and Street is aiding and abetting harassment and retaliation under a California employment rights statute. But aiding and abetting under California law requires that Wallace and Street knew that others' conduct violated the California employment statute. The Fair Employment and Housing Act. Okay. We've heard of that before. The first mention of the FEHA is not until the cause of action is alleged, and only includes the conclusory allegation that Wallace and Street knew their actions constituted unlawful violation of the FEHA. Okay. Hold on. There's a footnote here that I skimmed over. Earlier, a plaintiff alleges that one of the defendant's attorneys published statements with actual malice, claiming that defendants know that the core narrative advanced by Mr. Friedman that Ms. Lively fabricated made-up sexual harassment claims to seize control of the film is false. Okay. All right. Lively never alleges any concrete allegations about how or why Wallace or Street knew that the FEHA existed, let alone that anyone's conduct violated it in this case. Furthermore, the harassment is alleged to have occurred during the production of the film, long before Wallace and Street were allegedly involved in August 2024 in this matter. And the so-called retaliation is addressed in part of a single sentence, which alleges that Wallace and Street aided and abetted the discriminatory conduct, including but not limited to by participating in the above-described coordinated astroturfing campaign to discredit and bury Miss Lively. That claim, with the other two claims, should be dismissed for failure to state a claim. Okay. Without an underlying tort, there is no civil conspiracy. Okay. And the conclusion here, before we get to the declaration, which is the more interesting part of this. Wait, what is this? What are they citing here? Okay. As the court has surely noticed, this case attracts significant publicity, even as, perhaps, events of more consequence take place around the world. But this particular circus doesn't need any more rings. The claims against Wallace and Street should be dismissed, either on the merits or for lack of jurisdiction or improper venue, or, in the alternative, the claims severed and transferred. After all, Lively has already indicated a willingness to do battle and play in Texas. Oh no, okay. So Texas would be a logical spot for hostilities to continue, unless, of course, the court dismisses her claims on the merits with prejudice, in which case, as movements, it ends with us. Wait. One more time. I like that. Okay. So Texas would be a logical spot for hostilities to continue, unless, of course, the court dismisses her claims on the merits with prejudice, in which case, as movements, it ends with us. That was awesome. Oh, that was really country. That's a very Texas way of saying this. That was really savage. It was like really like, and like somebody said in the chat, you can tell this wasn't just made for PR because it was boring. Most of it was boring. We haven't gotten to the declaration yet, which has some interesting little quotes in it. But the end of that was, I like that. That was good. But anyways, what was this? So this is what they cited in footnote 6 there. It's a Daily Mail article. Let me move my head. Blake Lively gives bizarre response to the chaotic South by Southwest premiere of Another Simple Favor. Okay. So Blake Lively claims she felt the love at Another Simple Favor premiere. The actress who was seen stepping back to the limelight took to Instagram to share a number of snaps. Okay. The premiere had its fair share of controversy from a protester holding a Justice for Justin Baldoni Blake Lied sign. Okay, we know all this stuff. She compared it to a rock concert. Okay. This is a boring article. What were we supposed to get from this? Okay. If anybody knows like exactly what they were trying to point to in this article, please let me know because I can't really tell. Yeah, the martini-shaped purse threw me off. I don't understand fashion, guys. It's not for me. All right. On Monday, Lively was accused of beefing up the crowd at the premiere. Why is the director of Another Simple Favor's wife pretending to be a fan in the crowd, waiting for Blake on the red carpet to take a selfie? Watch how many PR bots reply, "This is normal, internalized misogyny, and why do you care?" The poster added. I mean, where's the lie? Oh, and there's Colonel Kurtz. Okay, I think we don't really need to go through the rest of this. It's just more of the same stuff we've already seen. Okay, well, let's go back to this to get to the declaration. Maybe the reference to Texas in her caption? I guess so, man. I guess so. Basically, you're my good night story time, and I appreciate you doing all... Well, thank you very much for listening. Okay, we're done with that. Here's the Declaration of Jed Wallace, which is where like some of the interesting quotes come from. Let me actually zoom into that just a tiny bit more. Okay. I, Jed Wallace, declare as follows. 1, my name is Jed Wallace. I'm over 18. Blah, blah, blah. He lived in Texas. After attending Fordham, he moved back to Pennsylvania. Since moving to Pennsylvania, he only visited New York 4 times. Okay. And the visit in 2024 was a family trip, no business. Okay. Street is a crisis mitigation firm engaged by clients to help navigate real-life human crisis, threats, trauma, and mental health concerns. I have been the only officer and director of Street. Neither I nor Street reasonably expected any of my conduct to have consequences in New York. I in no way would I consider myself or Street at home in New York. I have read Miss Lively's amended complaint and am familiar with the allegations against me and Street. Prior to the filing of the amended complaint, Miss Lively filed a complaint with the California Civil Rights Department. I understand that the CRD complaint was provided to the press. The CRD complaint is attached as Exhibit 5, and the complaint attached to the CRD complaint is attached as Exhibit 6. And like I said, we've been over those things before, but I am going to post this document after the stream anyway, so you can always skim through it if you want. My earliest involvement in my limited role concerning Justin Baldoni and Wayfair was August 2024. I'm the only employee of Street that engaged in that limited role. All of it was done by me from Texas. None of that was in New York, and none of it was directed at New York. Neither I nor Street posted anything on social media on behalf of the Wayfair parties or about Lively, Reynolds, It Ends With Us, or any of Lively's or Reynolds' businesses. Neither I nor Street have ever asked or directed anyone to post about, comment on, or like any social media post about It Ends With Us, Wayfair, Justin, Blake, Ryan, or any of Lively or Reynolds' business or family. I never published, directly or indirectly, any information or content, negative or otherwise, regarding Lively. I have never met or interacted with Lively. I do not have a digital army in Los Angeles, in New York, or anywhere else. I do not have, work with, or direct a team in Hawaii. I have never been to Hawaii. I have an understanding of what a social combat or social manipulation plan could be, but that is not a service I provided related to It Ends With Us, Wayfair, Justin, Blake, Lively, Reynolds, or any of their businesses or family. I do not specialize in executing confidential and untraceable campaigns across various social media platforms to shape public perception. And this is where I said, guys, before, I've seen comments about this guy, so like there might be more to him than I realize, but I just haven't had time to really get into it. So I will eventually. I just, so busy right now. Okay. In early August 2024, I was contacted by Melissa and Nathan about Justin Baldoni and potential stories or social media attacks on him. My job was to read, analyze, and assess all forms of media and trends taking place with respect to various issues. This job was in line with my work generally with respect to all forms of media. Specifically for the events related to Mr. Baldoni, my limited job was to conduct analysis of the media climates. In doing so, I reviewed all forms of media, analyzed the sentiment of the coverage, and then provided updates on my observations. Most times, my feedback took the form of informal comments that I made to Miss Nathan, who I understood to be in California. After passively observing the social media environment, I saw an organic outpouring of support for Justin Baldoni and the film. This observation led to my comment, "We are crushing it on Reddit," which is something we've seen before, right? We've seen reference before. My feeling based on what I saw was that no actions needed to be taken at that time, and that everyone should let the sentiment on the social media unfold organically. In addition to observing that people on social media organically supported Mr. Baldoni, there appeared to be a dislike for Miss Lively based on her tone-deaf promotion of the film. Therefore, my advice was not to do anything at that time and let the sentiment on social media continue to unfold organically. Somebody says, I think Lively literally doesn't know what this guy does and just saw his name come up and figured Discovery would tell her what he does. Dude, I think her publicist, though, Sloan, does know who he is. So that's probably, where that came from. But yeah. Okay. My limited work related to Justin Baldoni concluded in early November 2024. Neither I nor Street had anything to do with the production of It Ends With Us, and I was never on the set of the film. Because I provided feedback to Miss Nathan, who I understood to be in California most, if not all the time, I only considered the impact of my work to be in California. The goal of my work was to inform her and her team, who I anticipated would be in California, and I thought of her work as for Wayfarer Studios, which I knew and know to be based in California. In other words, I thought I was doing business and providing my services to individuals in California. Neither I nor Street communicated or caused content to be provided to any journalist, content creators, or media entities anywhere, let alone New York. To be clear, I did not speak to any journalists at the New York Post or at the New York Times regarding the issues set forth in this lawsuit. My role on social media was merely passive observation and analysis of the social media environment as it pertained to It Ends With Us. Lively alleges, among other things, that I participated in a conspiracy to commit tortious conduct or unlawful acts against her. I did not. If that conspiracy even exists, which I doubt, I have no knowledge of it because I was not involved. I had and have no desire to torch Lively or her reputation, or you kind of did a little bit with these statements. Nor did I act on that imagined desire with anyone. And so, I have no desire to torch her, but here, let me just torch her a little bit. Oh my God. I had and have no desire to torch Lively or her reputation, nor did I act on that imagined desire with anyone. Okay. On January 21st, Lively filed a Rule 202 petition against me in Texas. On February 4th, she non-suited the petition. A true and correct copy of the Rule 202 petition is attached, and the motion to non-suit is attached as Exhibit 2. On February 4th, I filed a lawsuit against Lively in the Western District of Texas, asserting claims for declaratory judgment and defamation. Okay, and that is attached as Exhibit 3. Lively's responsive pleading is due April 4th. A true and correct copy of email confirmation from her Texas counsel is attached as Exhibit 4. This must be pertaining to his health stuff because it's redacted. Travel to and from New York would be difficult financially for me. Not only would consistent travel be a major expense, it would disrupt my ability to make a living as I do most of my work in Texas. I believe my financial resources pale in comparison to Lively and her husband. I declare under penalty of perjury that the foregoing is true and correct. And then that's where all the exhibits start, guys. So yeah, I thought there was some interesting tidbits in there. I will go ahead and post the link to this document in the description of the video, and in the comments, and then also on Twitter. So Thanks for joining me, everybody. I have some more work that I have to do, so I can't really stick around too much longer. Let me make sure I didn't miss anything while we were going over that. One sec. No, we're good. Okay. I was like, please tell me there's not like 4 more filings. No, we've gone through everything today. So assuming nothing comes up before midnight, I think I can finally call it a day. We'll see. I probably shouldn't have said that, though, because now it's going to come back to bite me. All right. Thank you, everybody. Please hit the like on your way out. Give me 1 second, actually. Let me redirect you to my friend. What friend do I want to redirect you to? Look at me pretending I have friends. Oh, hold on. We got the baby goat cam is on. Yeah, let's send you to Valhalla. So this person that I know from streaming is they have a live baby goat cam. I guess the goats they have are giving birth. I don't know if you want to check out baby goats or something. Send them some love. Tell them Lethal Lore 904 sent you, and I will see you guys tomorrow, barring anything crazy that happens in the next 2 hours. So, goodbye.